Good afternoon, everyone. I'm George Garvey, the Associate Dean for Academic Affairs, and I'd like to welcome you to the third and last presentation in the 2010 Columbus School of Law Student Scholars Series. The series was instituted to recognize notable legal scholarship produced by members of the student body during the academic year, and also to foster the skills associated with presenting and defending that scholarship in a professional, conference-style setting. This year, our audience has been privileged to hear impressive work on a variety of subjects, including executive compensation calculations presented by fourth-year evening student Tiffany Rowe in February, Internet defamation standards presented by fourth-year student Nance Rickard in March, and finally today's work involving legislative restraints on Internet surveillance by our second-year student John Heekin. I'm very pleased to be welcoming you on behalf of the Dean, and at this point let me turn this over to Professor A.G. Harmon, who will make the introduction of our principal speaker today. Thank you.
Thank you, Dean Garvey. Before I introduce John, I'd like to first introduce the respondent to the presentation today, Timothy Nagle. Mr. Nagle received his J.D. cum laude from Suffolk University Law School and his LLM from the University of Virginia. A naval officer from 1979 to the year 2000, he was designated Judge Advocate in 1986 and has served as Deputy Assistant Judge Advocate General, Special Programs, Deputy Assistant Judge Advocate General, International Law, and Deputy Associate General Counsel with the National Security Agency. As Program Manager at TRW Northrop Grumman, he advised on network security and critical infrastructure issues, and currently he is an Assistant General Counsel with Bank of America, providing legal support to the Chief Information Security Officer and Corporate Security Executive, among other responsibilities involving security and intelligence. So we thank you, Mr. Nagle, for joining us today. Honored to have you here. As I said, the last of our student scholars presentations will be made by second-year student John Heekin, a 2005 graduate of Bucknell University with a major in political science and a minor in legal studies. Prior to entering law school, John worked as a legislative coordinator for a nonprofit and was a legislative writer with Blue Cross Blue Shield Association's Federal Policy Office. Here at CUA, John has pursued a certificate in the Comparative and International Law Institute and studied abroad with the International Business and Trade Summer Law Program in Krakow. He is a member of Pi Alpha Delta Legal Fraternity, will serve as Senior Lead Articles Editor for Volume 27 of the Journal of Contemporary Health Law and Policy, and will compete with the Moot Court Trial Team next year. This spring, he has worked as a law clerk in the Department of Justice's Criminal Division with the Office of International Affairs. John's research sprang from Professor Michael Noon's seminar on legislative oversight of the intelligence function, and focuses on the different legislative approaches undertaken by the United States and the United Kingdom to regulate surveillance and interception of electronic communications. I'll now turn the floor over to the last of our 2010 student scholars, John Heekin. The topic of his presentation, Leashing the Internet Watchdog, Legislative Restraints on Electronic Surveillance in the U.S. and the U.K. John.
Thank you very much for coming. This is a pretty interesting topic, so I'm going to do my best to keep the presentation interesting as well, but feel free to doze off if you need. I'm just going to give you a brief background of legislative oversight. It's basically divided between two main approaches. The first is investigation. The second is legislation. Through investigation, it's the process of ensuring compliance with national laws and monitoring the activities of security and intelligence agencies. Legislation, on the other hand, is the means by which mandates governing conduct are issued. I chose to focus on legislation because it's the most forward-thinking approach. It answers present problems while considering future issues as well. Just as a brief introduction, I chose the topic as part of the Professor Noon's class on comparative law, legislative oversight of the intelligence function. I had originally intended to focus on the FBI's carnivore program, which I'll speak about later, but that quickly became the mere launching point. This is an area of interest for me, but it was one that I was not largely familiar with prior to doing this research. I certainly had no idea how far the rabbit hole went on these topics. And it also turned out to be extremely timely. We have Jihad Jain on the right and Nagle Hassan, the Fort Hood shooter. All of these incidents took place towards the end of my article, unfortunately. Additionally, developments in the UK with new laws passed dealing with electronic surveillance have also come to light. My approach, originally I approached this as a position paper. I intended to have an argument. I came into it with my own perceptions and thoughts. As I was doing my research, I realized that I had no single cohesive theory on what we should do with electronic surveillance of internet communications. So ultimately I decided to write it as more of just a comparative analysis, presenting the issues and letting the ideas fall where they may. My conclusions from this, obviously there's no single silver bullet to address the threats on the internet, either from government surveillance or from criminals. There are many solutions out there, but few offer concrete ideas that can properly balance security and privacy without compromising one or the other. The U.S. is very proficient at creating frameworks for oversight and regulation. However, it's just as good at violating those regulations and finding loopholes. The U.K., on the other side, oversight is a recent development, but much of their authority rests in the executive branch, and security sometimes openly holds primacy over privacy. This presentation is going to just cover basically a cursory overview of these topics because in the interest of time and attention span, I don't think we'd be able to delve too deeply into it. I'm going to start off with the technological aspect of the argument and introduce data mining and its uses. I will also briefly discuss one of the more infamous investigative uses of data mining, which is the FBI's carnivore program. I'm going to next move on to the concept of individual privacy. Its foundations in the U.S. are the Fourth Amendment. In the U.K., we have the European Convention on Human Rights, and then implemented into national legislation, the Human Rights Act of 1998. And then I'm going to move on to legislative oversight. There's a common theme, and it's that legislative changes in both countries really came only after scandal or violations of the existing statutes. FISA was developed from the national security loophole of Title III and widespread surveillance scandals noted in the Church Committee. The Interception of Communications Act and Regulation of Investigatory Powers Act in the UK came from European Court of Human Rights rulings against the UK, finding violations of privacy rights. And then lastly, I'm going to note on some particularly provocative recent developments in both countries. Data mining. Data mining is the process of using automated analysis technologies that apply an algorithm with manually configured collection restrictions to a large compilation of data sets to connect independent but related pieces of information to develop useful patterns that may be exploited for business, scientific, or domestic security purposes. Now, that is a mouthful to read, so I'm sure it's difficult to comprehend. Essentially, data mining is it's a program that sifts through huge quantities of data and looks for relevant items. Relevant items are defined by specific criteria within the program that extract individual data pieces from the ocean of data that's mined. The principal utility of this is it can answer a question that has not yet been raised. It identifies tangential relationships among data points that are not otherwise obvious but exist within the data itself. Kind of an extremely dumbed-down version to think of this is the 3D art posters, how you can look past it and an image pops out at you. Data mining would have a blank canvas and that 3D art, and it would extract the image and put it on the blank canvas for you. So you no longer have to cross your eyes, you don't have to look past it. The image is right there. It really helps out with a lot of investigative purposes. The data that is mined can actually be organized in a number of ways determined by the user. It can be formed into a simple summary, it can be a descriptive model, or it can be a predictive analysis of relationships. And then the stages of data mining, there's the pre-processing stage in which the relevance criteria is defined, the data is collected, and then the data is cleansed, so redundant data is removed. The descriptive or predictive modeling stage applies algorithms to the data and reveals the unknown relationships or patterns that exist within it. There are two approaches. There's a top-down approach, which starts off with a hypothesis and attempts to use the mined data to substantiate the hypothesis. There's a bottom-up approach, which starts off with the data sets itself and then develops hypotheses out of that. And then lastly, we have the post-processing stage, in which patterns or relationships are interpreted for their usefulness. It's at this final stage that the human review is the most critical to ensure oversight and also to minimize false positives. The FBI's Carnivore program. It developed Carnivore as an investigative tool designed to filter and record predefined data packets traveling through the ISP's Ethernet. It was used only in judicially authorized programs when alternative programs were either unavailable to meet or insufficient to meet investigators' needs. It was named Carnivore actually because it was able to select the meatiest parts of the data and extract them, as opposed to the original version of the program, which was called Omnivore, which just took everything out. Carnivore was revealed in a July 2000 news story by the Wall Street Journal. Unsurprisingly, a lot of panic ensued, and general fear over the widespread government surveillance was the norm. Congressional hearings were held in July and September of 2000 to look into the capabilities and use of Carnivore. By that time, the FBI had wisely renamed it DCS 1000, and an independent review was also ordered by the Department of Justice. Its findings principally supported the use of Carnivore. The program was found to be properly designed to prevent general trawling. It was implemented only under judicial authorization, and the safeguards minimized collection of general information. It also found that the safeguards in Carnivore were actually superior to that of commercial alternatives. Like I said, data mining is not unique to the investigative function. It's used in business. It's used in many different fields. So there are numerous different programs out there that can be used. The outcome of all these investigations, ironically, was that pressure on FBI's use of Carnivore may have decreased civil liberties, because ultimately the FBI reportedly abandoned Carnivore in favor of the commercially available alternatives, which were shown to have weaker safeguards. Next, I'm going to turn to the issue of privacy. The U.S., we have the Fourth Amendment, which is the principal constitutional provision that safeguards individual privacy. But it's important to note that there's no specific statutory reference to a right of privacy therein. Without express statutory language, the concept of privacy has relied on case law for interpretation. In my review, I focused on the case of Katz v. United States, Smith v. Maryland, the beeper transmitter cases of U.S. v. Knotts and U.S. v. Caro, and then lastly, Kelo v. U.S. And I wanted to really measure the impact of technology on privacy considerations, and that's why I selected these out of the extremely broad jurisprudence on the Fourth Amendment. On the UK side, the UK actually helped to draft the European Convention on Human Rights in 1950, but it did not incorporate it into national law. Article 8 in the ECHR is the express recognition of a right to individual privacy. However, without incorporation in national law, the UK was bound only to make its best effort to comply. And UK courts also lack jurisdiction to hear claims of violation. Ultimately, the UK did implement Article 8 and the other provisions of the ECHR into its national legislation through the Human Rights Act of 1998, which came into force in 2000. On the United States side, let's briefly go over these. The first is Katz v. United States. It was a shift from the property-based perception for the Fourth Amendment, and it was a recognition that the Fourth Amendment protects people and not places. There was a strong emphasis on the warrant procedure, but obviously Katz is most notable for Justice Harlan's concurrence, which introduced the two-prong reasonable expectations test. It stated that a privacy interest exists where the individual has a legitimate expectation of privacy, and that expectation is one that society is recognized to, or is prepared to recognize as reasonable. However, the subjective, prong has been heavily criticized for its susceptibility to defeat whenever a person's aware of something that might defeat a privacy expectation. Smith v. Maryland is a pen register case where police applied a pen register to monitor the phone numbers dialed from a private residence. This dealt with a knowing and voluntary disclosure of information to defeat the claim of privacy. Ultimately, it was found that knowledge that information is not private does defeat privacy, because the person dialed phone numbers, and those phone numbers had to be sent to the operator before they were connected to the recipient. By disclosing the information to a third person, there's no privacy interest in that information. In the cases of U.S. v. Knotts and U.S. v. Carroll, in Knotts, a beeper transmitter was attached to a can of ether and used to track a criminal suspect as he traveled along roads and public highways. It was noted that nothing in the Fourth Amendment prohibits police from augmenting the sensory faculties bestowed upon them at birth with such enhancement as science and technology afforded them. So the principal point of U.S. v. Knotts was that all the surveillance took place on public roads and highways. In Carroll, however, the beeper transmitter tracked movements along public areas, but then the individual moved within his home. As soon as the threshold of the home was crossed, the police conduct was no longer reasonable without a warrant. So the ultimate finding here was that sense-enhancing technology is permissible in public spaces. Lastly, Kelo dealt with thermal imaging technology. Its use was actually deemed impermissible by the government in this case, but the reasoning really opened the door for future susceptibility. The court noted that though technology had eroded privacy interests, you can't use technology that's not in general public use without violating the privacy interest. However, by that reasoning, once technology is widely publicly available, if it can monitor an otherwise private situation, then that situation is no longer private. So presumptively, the privacy expectation can be defeated in cases where the government uses technology that's widely publicly available. Individual privacy in the UK. As I said, the European Convention on Human Rights, Article 8, states that everyone has the right to respect for his private and family life, his home, and his correspondence. However, it's the second aspect there that allows for something of a loophole, and that there shall be no interference by a public authority except in accordance with the law. When the UK implemented the Human Rights Act of 1998, it drew upon the ECHR, but in doing so, it also incorporated the second provision there, which meant that the government conduct must be statutorily authorized. So there's no actual protection preventing that right from being contravened by subsequent legislation within the UK. When legislation is subsequently passed that happens to contravene against the privacy interest, the court dealing with the violation will make a declaration of incompatibility, which essentially means that both statutes are still valid, both are still enforceable, and basically the court's just making a persuasive argument to the legislature to make a change. There's no actual pressure on the legislature to make that change. So essentially, Parliament can overcome the right to privacy just by passing subsequent statutory language. Privacy comparisons across the pond. This is just pretty straightforward. You got Fourth Amendment versus Human Rights Act. In the Fourth Amendment, it's a negative right. It's a right to be free from unreasonable interference, whereas in the UK, it's a positive right. It's a right to respect for your private life. There's an inviolability of the Bill of Rights to a degree. We can't pass laws that directly contravene the Bill of Rights, whereas in the UK it is possible, thanks to the provision for the Declaration of Incompatibility. Legislation can be passed that violates any right to privacy. And then in the U.S. side, our claims of violations of the Fourth Amendment are subject to judicial interpretation of reasonable expectations, whereas in the UK, claims of violations of Article 8 are limited to a review of whether or not the action was taken in accordance with the law. All right, turning to the development of statutory oversight mechanisms, Title III was enacted in the wake of U.S. v. Katz and congressional hearings investigating the practice of warrantless domestic surveillance by the executive branch. It represented the first piece of legislation that required the executive branch to obtain a court order prior to surveillance. It distinguished between domestic criminal investigations and foreign surveillance operations, reserving for the latter all executive powers necessary to obtain foreign intelligence information for national security. The national security loophole proved easily exploitable. It was successfully challenged in the case of Keith, which is that long case up there. It was nicknamed Keith for the judge who heard the case. The Supreme Court recognized that the President's authority to act in the interest of national security remains true, but he may not do so in a manner incompatible with the Fourth Amendment. Next, we have the Senate Select Committee to study government operations with respect to intelligence activities, nicknamed the Church Committee after Idaho Senator Frank Church. It became clear that despite Keith, there was a distinct need to fill foreign intelligence gaps in Title III. On the UK side, the case of Malone v. United Kingdom was the impetus for the passage of the Interception of Communications Act. In Malone, police implemented a phone tap on an antiques dealer, and even though it was under authorization by the Secretary of State and a warrant was actually issued for it, UK statutes did not recognize wiretapping as a legitimate form of surveillance, so technically it was not in accordance with the law. As a result, the 1985 Interception of Communications Act was passed, and it specifically authorized and established procedures to obtain a wiretap warrant. However, it did have significant loopholes in that its warrant procedure was not overseen thoroughly, and so many times warrants were not obtained. Shifting back to the U.S., we have FISA 1978 was an attempt by Congress to limit the executive branch's power to conduct warrantless surveillance while leaving sufficient authority to address legitimate threats to national security. It supplemented but did not replace Title III. Domestic criminal investigations were still under the jurisdiction of Title III, while foreign intelligence gathering and national security issues became the responsibility of FISA. It established the Foreign Intelligence Surveillance Court. Again, given the sensitive nature of national security matters, we needed a secret court to issue warrants and also to hear claims of improper surveillance. Under FISA, surveillance operations were initiated in one of three ways. First was by certification of the Attorney General. This was the only method under which surveillance could be conducted without a court order. Surveillance was permitted for up to 1 year. The Attorney General had to certify, however, that the surveillance was intended only for foreign intelligence, only foreign agents were targeted, and there was no substantial likelihood that U.S. persons would be targeted. Secondly, the emergency powers of the executive branch was another way to initiate surveillance operations. Under this, a 24-hour authorization by the Attorney General was permitted upon reasonable determination that an emergency required immediate action. After the 24-hour period, the Attorney General had to make the standard presentation to the FISA court in order to obtain a court warrant, or the surveillance had to be terminated. And then lastly is by a FISA warrant itself. The Attorney General had to apply for a warrant. He had to identify a foreign target, describe the surveillance employed, and certify the information sought was for the purpose of foreign intelligence. Sufficient detail was necessary to justify probable cause. And also, it had to be established that no less intrusive means were available to accomplish the same ends. Following the terrorist attacks on 9/11, the executive branch demanded broader authority to conduct electronic surveillance. Revelations of the role of electronic communications in the planning of the attacks really played into this. The greatest impact on FISA actually came from one of the smallest amendments. Excuse me. Under the original FISA, surveillance was only authorized if it was for the purpose of acquiring foreign intelligence information, whereas under the amendment in the Patriot Act, surveillance was now authorized if it was for the significant purpose. Essentially, the purpose of surveillance no longer had to be primarily for foreign intelligence. Also, the FISA court interpreted the new language extremely broadly in a 2002 decision and applied the significant purpose test to government surveillance operations. The effect of this was that domestic surveillance could be authorized under FISA instead of Title III, and foreign intelligence is no longer a primary requirement for FISA. It may be a secondary objective so long as it's still significant. Next, the Protect America Act. It codified a gray area that was exploited by a 2002 executive order. The executive order offered a warrant exemption for secret NSA surveillance that was performed on international calls and electronic communications sent from within the U.S. to recipients outside the U.S. Congress adopted the Protect America Act 2007 to address this, by granting intelligence services authority to conduct surveillance from within the U.S. of foreign communications for up to 1 year without court approval. It was heavily criticized, and it was very short-lived. It expired after its 6-month term, but it did serve as the building blocks for the continued broad authority under FISA 2008. FISA 2008 was drafted to clarify the means by which government could implement covert electronic surveillance. It identified itself, Title III, and pen register and trap and trace legislation as the exclusive means by which surveillance operations could be lawfully initiated in the U.S. Its stated rationale was to counter contentions that the government couldn't legally act outside the scope of FISA. It also sought to expand the authority to conduct surveillance of targets located abroad and to enhance oversight mechanisms to govern interception and surveillance operations. The FISA 2008 foreign surveillance targets under Title VII defines three broad categories of surveillance targets. The first is non-U.S. persons who are reasonably believed to be outside the U.S. FISA authorization requires the Attorney General to certify that the scope of the surveillance is limited to non-U.S. persons. The persons are reasonably believed to be outside the U.S., and appropriate minimization procedures are in place to prevent the direct or indirect targeting of a person known to be in the U.S. or known to be a U.S. person. The next two categories deal with U.S. persons. The first is those who are reasonably believed to be outside the U.S. whose communications pass through the U.S. So the person lives abroad, but their communication passes through domestic channels. The second is U.S. persons reasonably believed to be outside the U.S. whose communications remain outside the U.S. This authorized surveillance conduct abroad. So U.S. agencies can now surveil U.S. persons abroad. However, it was one important note was that they could conduct the surveillance, but they must obtain a warrant if the citizen has a reasonable expectation of privacy. It's important that this recognizes that the Fourth Amendment travels with U.S. persons outside the U.S. It's similar to Justice Stewart's statement in Katz that the Fourth Amendment protects people, not places. FISA also included new oversight mechanisms intended to prevent abuse of the already broad powers granted. The Attorney General and the DNI must assess compliance with targeting and minimization procedures semi-annually and submit those reports to Congress, the Congressional Intelligence Committees. The Inspectors General of DOJ and the intelligence communities must submit semi-annual reports to Congress identifying the number of intel reports that reference U.S. persons. That's an important measure to ensure that the targeting procedures are being followed and that U.S. citizens aren't being subjected to surveillance without proper authorization. And then lastly, the Attorney General must submit to the Congressional Intelligence Committees all FISA court decisions that significantly construct or interpret any portion of the FISA 2008 provisions. This ensures appropriate judicial application and interpretation of the statute to fulfill congressional intent, rather than allowing the FISA court to make interpretations not in line with what Congress wanted. On the UK side, similar to the Interception of Communications Act, it was a decision of the European Court of Human Rights that led to the present legislation governing UK surveillance. The case of Halford v. UK dealt with the secret wiretapping of home and work telephones. The court found that it violated Article 8 of the European Convention on Human Rights and actually used similar language to Katz v. U.S. To describe the reasonable expectation of privacy that one has in their phone calls. It's interesting that the court also noted that the reasonable expectation of privacy in her work telephone calls was because she had not been told that they were subject to monitoring. So that's the subjective expectation that could technically be overcome had she been aware that monitoring was possible. However, it was found to be a violation because it was performed without a warrant, and thus it was not in accordance with the law. So the court didn't actually recognize a privacy right that superseded a government interest. It basically upheld that the government had to follow its own laws. So facing the risk of repeat violations of the ECHR due to procedural shortcomings of the Interception of Communications Act, the UK drafted new legislation. The Regulation of Investigatory Powers Act was the result. It's been criticized as something of a misnomer, however, arguing that it doesn't actually regulate anything. It really just authorizes broader government authority to spy on its citizens. The key provisions of RIPA include new communications interception requirements. Like the U.S., they must have advance authorization to conduct surveillance intercept operations. But there's a notable difference in that in the U.S., warrants must be obtained from the judiciary, whereas in the U.K., warrants are obtained from the Secretary of State, so the executive branch. Specific interest, the operation must also be proposed in the name of a specific interest, namely national security, crime prevention and detection, or the economic well-being of the UK. Also, the operation must be shown to be a proportionate means to accomplish the interest. and the Secretary of State must consider whether information could be obtained by less obtrusive means, and also must specify an individual target or premises. So this is similar to the particularity requirement in the U.S. The Secretary of State is also given authority to require telecommunications operators like the ISPs to maintain a capacity to cooperate with intercept operations. This primarily relates to compliance with the Data Protection Act of 1998, which protects against disclosure of personal information. And ISPs are required to supply authorities with encryption keys for encrypted data intercepted during surveillance operations. It should be noted, however, that that provision is not unique to the UK. The US does have its own legislation. It's called CALIA, the Communications Assistance Law Enforcement Act, I believe, and that requires ISPs to be able to cooperate with U.S. law enforcement investigations. RIPA also includes oversight of its powers, but not by Parliament. It authorizes the commission of 4 commissioners. The first is the Interception of Communications Commissioner, who is tasked with reviewing the performance of the Secretary of State in issuing intercept warrants. The next is the Intelligence Services Commissioner, who monitors the activities of intelligence services and the Secretary of State's performance related to those agencies. And next is the Chief Surveillance Commissioner, who oversees all surveillance activities to ensure compliance with the law. And then lastly is the Commissioner for Northern Ireland, who oversees all activities in Northern Ireland. There are also reporting requirements. Each one of the commissioners is required to submit an annual report detailing their substantive oversight, and they issue that to the Prime Minister, who then submits copies of the reports to Parliament. However, the Prime Minister redacts significant portions of the reports to remove sensitive information and national security information. The RIPA also established the Investigatory Powers Tribunal, which is somewhat similar to the FISA court. It has exclusive jurisdiction, whereas the Human Rights Act technically brought the ECHR provisions within domestic jurisdiction for their courts. RIPA actually kind of pulled it away. So now this is the only court who's able to hear claims alleging violation of the ECHR provisions by the government. And its decisions are extremely secretive. The complainants often receive only minimal information as to whether their judgments were in their favor or against. And reports of violations of the Human Rights Act are given to the Prime Minister, but there's no further disclosure. There's no parliamentary oversight, unlike the provisions in FISA 2008. Recent developments. As I said, I think I wrote this article one semester too soon. There were several developments that took place in October, November, December, up through January that have really impacted the scope of this information or this article. On the U.S. side, we have the Fort Hood shootings, and it's been revealed in the aftermath of the shootings that the FBI had actually intercepted emails between Nagle Hassan and Anwar al-Awlaki. And information that came out about those interceptions proves that they were content-based interceptions. It has not been substantiated whether or not they were conducted under a warrant or under any authorization. So there are some difficult complicating factors on that, and that's Hassan was in the Army. So it's unclear whether or not he's subject to a higher level of scrutiny because he's in the armed services and his communications aren't protected by a level of privacy. And then also al-Awlaki is a terror suspect, and it's unclear whether there was an ongoing operation or whether there already was a warrant issued to monitor his communications. It just happened that they found Hassan as well. Anwar al-Awlaki, he's been called the bin Laden of the Internet. He's been linked to both Nagle Hassan and Umar Farouk Abdul Muttalab, the Christmas Day bomber, Northwest Airlines, or attempted bomber. The Internet has proven to be a very, very useful medium for terrorism. Al-Awlaki actually has his own Facebook page. He has his own blog, website. He's pretty widespread. He has pretty extensive communications. I think that actually the U.S. just issued a kill order on al-Awlaki recently. And it's been noted that Al-Qaeda is no longer coming to recruits. Recruits are using the web to go to Al-Qaeda through YouTube, MySpace, Facebook. And then lastly, we have some legislative oversight. The Senate Homeland Security Committee has initiated an investigation into the Fort Hood shootings. and just this past Monday subpoenaed documents from the Pentagon and FBI related to those to the case. However, the Obama administration has refused access. They have argued that disclosure would possibly jeopardize the prosecution, and also that they want to avoid public disclosure of electronic intelligence information they've gathered on al-Awlaki. So they're kind of stonewalling the committee's efforts at this time. Additionally, Congressman Pete Hegstra has come out. He's made remarks that the Obama administration has actively concealed information from the Gang of Eight, which are it's a group of high-ranking congressional members, the chair and ranking member of both House and Senate Intelligence Committees, the minority and majority leader in the Senate, and the speaker and the ranking member of the House. And that the fact that the Obama administration has obscured information from them is a little troubling, particularly because they're usually in the know with a lot of national security issues. On the UK side, we just start off with a little background. This is not so recent. The EU Data Retention Directive was passed in 2006. ISPs, Internet Service Providers, are required to store customer traffic data relating to telephone and email communications. It targets data identifying the caller, the time, the means of communication, and it's used for the investigation, detection, and prosecution of serious crime. It's important to note it is not content related, and the data retained is retained for no less than 6 months, no more than 2 years. Building off of the Data Retention Directive in the UK, this Communications Capabilities Directorate was just established in January 2010, despite actually being tabled in the summer or fall of 2009 under heavy criticism from the press and the public. It incorporates 2 teams. The first was a traditional wiretapping team, which dealt with telephone and email communications. The second is the Interception Modernization Program, which deals with new communications, internet telephones, and instant messaging. It builds off the Data Retention Directive in that it requires ISPs to maintain web traffic records on all UK residents. It also requires formatting records so that the web communications could be linked to their mobile phone communications. Essentially, what this does is it pinpoints the location of the individual, and you're able to track them and see where they're going, who they're talking to. It's been pretty heavily criticized as Orwellian, and also that it violates the Data Protection Act of 1998, because the interception is neither necessary nor proportionate. It's just basically general trawling. They've also been issued a £2 billion budget to be spent over the next 10 years, and in the past 2 months they've spent £14 million doing unknown activities. So there have been several calls for Parliament to start overseeing this money. They're just dishing out to the Communications Capabilities Directorate. So questions going forward, I guess I'll just leave you with 2 questions that have really come up. I've had more questions than answers, actually, unfortunately, from this paper. First is there really privacy on the Internet? And second, is monitoring the Internet for illegal activity justifiable? In this second question, I kind of drew upon the case of Illinois v. Caballes from our criminal procedure class, as some of you may remember. It dealt with drug sniffing dogs. And in the holding, the justice said, any interest in possessing contraband cannot be deemed legitimate, and government conduct that reveals such possession is not unreasonable. So you can make the correlation that there's no legitimate expectation of privacy in committing illegal acts. So I thank you very much for your time and for coming, and that is the conclusion for me.
Nagle to conduct the response to John's presentation. Then we'll have questions from the floor. Nagle.
Thank you, sir. John, I really like this paper, not because I've been doing this for about 15 years, but because I think it's still very relevant. And as much as you're attempting to find answers, I know that we both know that they don't exist, at least yet. In fact, Tuesday, the Supreme Court heard oral argument in the case of City of Ontario versus Kwan regarding information about pager activity, police officers, city police officers, and whether the use of pagers, I mean, let's go back to the Stone Age and talk about pagers, whether information off of pagers can be used to discipline the police officers because the pagers were being used in an inappropriate fashion. So that you might think, well, what connection does that have to what we're talking about here today? But the same same concepts of reasonable expectation of privacy. There's always a relationship. In this case, it was employer-employee. But essentially, in any of these debates, there's going to be a relationship. And what are the respective expectations of the two parties in that relationship? So, and there was also some discussion about technology. What do we do? What if the technology is different? What if this had been email as opposed to pagers? Do we keep up with technology? Does the law have to change with technology? And I think it's safe to say that law never does. It never anticipates technology. It's reactive. When I first started at the National Security Agency, I sat in on one of the presentations by the senior counsel at NSA that had responsibility for supporting the signals intelligence collection units. And I was listening to his presentation with a colleague of mine, and he started it with the Magna Carta. And so I turned to this new colleague of mine, and I said, is this guy serious? I mean, why are we starting with the Magna Carta on a discussion about signals intelligence collection on the Internet? But as in most things, I've learned that the people that have been doing that kind of law for a while get it. So the Magna Carta was a respective responsibilities. We, the general public, expect our government to provide us certain services, and then we expect to have certain levels of control. I'm glad that in your paper you focused on the UK and the US as far as legislative oversight, because we have shared culture, shared expectations. The UK has the European Union notion of privacy that John described. We have our own notions of reasonable expectation of privacy. So let's assume that I'm a legislator and I want to do the right thing. My sole motive is to make sure that I can balance, as you said, privacy versus security. And let's say that the courts, that I'm relying on the courts to, if I overstep in creating legislation and providing oversight on that legislation, if I somehow do something wrong, then the courts are going to help fix that. And I'm also going to provide some, or allow some deference to the executive branch, because they are charged with implementing the statutes that I pass, and I should rely on them to implement those techniques and capabilities, to brief me on them, full and fair disclosure, fully and currently informed, I think is the phrase. And in fact, if I'm a member of the House Permanent Select Committee on Intelligence or the Select Committee on Intelligence in the Senate, unlike my UK brethren, I'm going to get classified briefings. I'm going to be told exactly what's happening, or at least I think I'm going to be told exactly what's happening. So I find out that we want to implement a new collection technology, and we need to implement it on the Internet, which is global, and we all share the Internet. We order from LL Beans on the Internet. The military orders supplies on the Internet. Terrorists apparently try to solicit new participants on the Internet. We all share the Internet. It's a shared space. This is not a piece of, an envelope that's being carried by the Postal Service from me to you. This is a shared space. So, and it is not monitored by any single entity. It just exists. So somebody comes in and tells me that I get in a briefing, and you're my legislative assistant, and I get a briefing on a new technology on the Internet for collecting information about people's social space interactions, MySpace, Facebook that you alluded to, Second Life, any of these social media interactions between either people that know each other or people that don't know each other or people that are not even acting in their true identity. They have an avatar of some kind of representation of themselves. And I know that there is email, there's web browsing, it may or may not be my name, but somehow it may be attributed to me, and I'm interested, I'm concerned about protecting the general public, and I want to build on FISA, which started in 1978, it's gone all the way to date, but I just don't know what to do, because I know that I need to protect citizens in the United States, or in the UK, the citizens of the United Kingdom. I want to make sure that I don't interfere with the reasonable collection by our law enforcement intelligence agencies, But the internet's evolving, technology's evolving. As you said, the ability to conduct data mining on previously disparate pieces of data, I can now create a profile of what you did today, yesterday. And maybe that's a good thing, because maybe that helps us get terrorists that were responsible for train bombings in London. Maybe, though, it goes the other way, and it violates the privacy rights of all of us who should be able to expect to interact on the internet, conduct commerce, talk to our parents, etc. So do I need to craft some legislation that is technology agnostic, or does it need to follow technology, and should it reflect the fact that I may put something on Facebook which my parents would never have dreamed of disclosing to even their best friends? So how do I do this? Do I need to aim ahead of the curve and get there? How do I do that? What balance do I strike?
I mean, certainly you can't be agnostic towards technology. You have to realize that you have to embrace it. I believe that on a number of different levels, from a personal level, we have to recognize that the internet may no longer just be a means of communication. It might actually now be a place. Like you said, Second Life. People have entire second lives online with these avatars. You have to recognize that the capacity of the internet is equally relevant for both good and evil. I think that eventually we do have to, or we will eventually see monitoring of all email or all web traffic. From a legislative perspective, I think that you also can't attempt to be ahead of the curve, because inevitably you're going to either overshoot, undershoot, or just completely miss the mark. You have to regulate how that information is treated. I think if you're going to intercept or conduct surveillance on a lot of web activity, I think we would have to create a judicial rule that you can only use whatever is captured outside of a warrant for investigatory purposes. You can't use it for evidentiary purposes. So it would be kind of like the exclusionary rule for anything you acquire without a specific warrant for that activity. So I would say if we're going to draft legislation along those lines, you can only govern human conduct, because you can't restrict the technological advances. So I guess that would be it.
So is it a sliding scale? If I'm more prone to blogging my opinions, or to posting on Facebook, to tweeting about my habits today, where I intend that maybe a certain audience is going to receive that information, but maybe not law enforcement, or maybe when I'm going into interview with the law firm that will hire me and launch me into a great career in the legal profession, and the first thing that happens is my prospective employer hands me a screenshot of my latest Facebook page with me with various beverages in my hand and various states of undress or disreputable behavior. Has that been a violation of my privacy? Or by placing it on the internet, as Smith versus Maryland says, to kind of twist the rationale, have I now changed my objective and societally subjective reasonable expectation of privacy, and that's fair game?
Absolutely. I believe that disclosure to third parties, particularly on social networking sites, that information is no longer private. As soon as a third person or thousands of your friends online can see what you've done, that information is open to view by all parties. So there's no violation of privacy there. If you're talking about monitoring web traffic in general, I guess you could even argue in US v. Caro, US v. Notch, that they're traveling along public spaces. The public highways are replaced by the internet superhighway, and that as long as they're in these public spaces online, like social networking spaces, that their activities are openly monitorable.
So I'm going to ask you another question. I don't want to take time away from the audience, but I was advised before in full disclosure on behalf of the faculty here, I was advised that the recording of our conversation would be posted on the university's website. So anything that you say is going to be generally known. So if I were to ask you about, let's say, your opinion on an internet protocol address, which is kind of the way that everybody on the internet, that's like our street address or our return address on an envelope or something like that. Let's just say that an IP address represents me. It may not have my name attached to it. It may or may not be private or personal. Reasonable minds have differed in the UK and in the United States. But let's say that my activity, whatever it is, web browsing, etc., anything I do, if I send an email, a service provider has to retain that. I mean, the government, if they put an eavesdropping device on outside of the phone booth, it's the government collecting the information. But anymore, 85% of all the communications pass along the private sector. So the government has to go to the private sector to get it. And the private sector has to understand what it's required to provide and does not have to provide. So if I send an email, that's going to get collected somewhere and cached or copied for backup purposes, or because maybe you haven't opened it yet, so it's still sitting on the email server. Or if you do web surfing, you may do it with your Catholic University web address or IP address, so the university system will capture that information for appropriate purposes, to include monitoring the security of their own network. If you post on anything, that's out there as well. So I want to kind of throw your first question back to you, remembering that this is being taped for posterity. Is there truly privacy on the internet? Or should we just assume that if it's put out there, it can be forwarded? If it's an email, it will be preserved, and maybe, as you mentioned, in the UK and the US, there are requirements on service providers to preserve all these communications. I mean, an envelope I can tear up and throw away. I can throw it in the fire, it will never be seen again. Electronic communications, as many people have since, to their consternation, been made aware of, exist forever. So if I put it out there, is it out there? If a web crawler gets it, it's there forever, and I have no privacy. So if I'm on the internet, it's user beware, there's no privacy out there, and the government can do whatever it wants. Would that be your position?
That's a difficult position to argue, certainly from a civil libertarian standpoint, that we'd all like to think that we're private. I think that on the internet, privacy is replaced by anonymity, and to the degree that you defeat your own anonymity by including readily identifiable facts about yourself, then yes, that information is out there, and I think we have to recognize that it is for public use, especially in the modern age. You were talking about IP addresses. You can go to Google and search any IP address, and it'll give you the relative street location of where that person is. I know that I used that in my externship this past semester. So, you're no longer, there's no, outside of living in a shack in Montana, there's no shack in Montana on the internet. You're always going to be subject to surveillance.
Is that a good thing?
It depends on what surveillance is going on. I think that we have to recognize that, like I said, that the internet is a place that can be used for good or evil. I think I'm a little shocked that there's not more general monitoring by the government. It's been a pretty hands-off approach so far. I think ultimately we will see that certain spaces are monitored by national or maybe international entities. I think that monitoring can be a good thing.
For what purpose?
See, that's where you try and get too specific, that's where you get into problems.
But remember, you're my legislative assistant, so you got to help me out here.
Absolutely.
I got cocktail parties to go to.
Yeah, that's true. Yeah. Well, I think most legislation is pretty obscurely written anyway. So. I would say that monitoring. I'm going to go back to the argument that if you're going to generally monitor, if you're going to trawl, it has to be solely for an investigative purpose. It can't be used as evidence in a case against you. It can be used to support further investigations. It can be used to kind of narrow down the focus and funnel in the investigations. But certainly it can't be used against you as a first interception.
Well, I hope that some of the hard balls, the curve balls that I've thrown at you, you should not infer that I don't think you've given a very good treatment of the subject here, because as you noted, it's difficult, and once you get down to, if I'm attempting to provide oversight, let's assume that members of the intelligence community or the law enforcement community who want to do well, want to discover misdeeds or anticipate and prevent misdeeds and don't want to be criticized after the fact because they pulled their punches, as we may be seeing now. So I want to do the right thing if I'm in the executive branch, and if I'm providing legislative oversight, I need to give them oversight. It has to be valuable, but I don't want to get in their way. So I think you've done a very good job of kind of laying out, if you will, the lanes in the road for this discussion. It's going to go either way. It's going to go, the church committee requires FISA to get us back on the rails, and maybe 9/11 requires the Patriot Act to get us back on those rails. Maybe it's a good thing that we're just kind of, we have general rails and we're bouncing between both of those in both the UK and the US. So I commend you on your paper. Thank you very much for allowing me to participate, and I guess I would open up to any questions anybody has.
For John.
Yes, copies are available.
Well, you acted as legislative aide earlier, so would you mind acting as my my campaign manager for a second? So I'm in Congress, and I'd like to stay in Congress, and it seems like the constituencies we have, they're afraid of things. They're afraid of terrorists, they're afraid of drug dealers, they're afraid of child pornographers, and the really moneyed ones are afraid of intellectual property pirates. These are all bad guys, and we have a right to be afraid of them. So it seems like I don't have a whole bunch of initiative, or there's not a whole bunch in it for me to closely oversee a lot of these intelligence gathering or eavesdropping activities, particularly on the internet, where we have the FCC's coming out with its internet policy principles. It's in the guise of net neutrality, but the carve out from all of those is these are only it only protects lawful activities. There's no protection for unlawful activities. The problem with that being, how do we know what's lawful and what's unlawful until we scan everything? And that sounds like a good idea because we have so many bad people out there. So what's my motivation to function in my oversight role? Why should I rein this in, since all the bad people are out there and the good people don't have anything to hide?
So you're looking to profit off the fears of your electorate? Or,
absolutely.
Okay.
It seems like the only people I'm protecting here are terrorists, drug dealers, child pornographers, and pirates.
By the only people you're protecting by not having monitoring, is that what you're saying?
No.
It seems like what you're saying is you don't want to oversee.
The only people I'm protecting by acting in my oversight role are the bad guys.
I guess I missed that point.
If oversight limits the ability
Okay, I see what you're saying.
to collect,
Gotcha. Okay.
should it be unlimited?
Yeah, why should I put on the brakes here?
I guess because the risk is that innocent people will be protected or will be targeted on or will be harmed by these activities. Yes, you should pursue to the furthest extent every crime and every criminal, but I think in an organized society, especially in a democratically elected society, we can't do so at the expense of our citizens. See, this comes back to the difficulty I had in writing this paper. I started off as a position. I don't have a single unique position. Obviously, I say that we have to protect our civil liberties. At the same time, there are these criminals out there. But there's no single way to conduct widespread surveillance that only targets criminals. I think that's a real difficulty. However, the oversight role is integral because while it may restrict the intelligence agencies to a degree, it protects our citizens, and that's the most important thing. So forcing them to act within the rules when the rules are fairly broad on both sides of the pond, that's really not forcing them to do a whole lot other than just to act reasonably. So.
To clarify something you said before about, so let's say I have, Facebook, MySpace, Twitter. Maybe I'll get a second live account to stay possible. So would you say that if I have my settings as private, for instance, but I have about 500 friends and probably about 300 pictures. Have I now given license to my future employer, or someone in the government to look into that, my pictures, my information, my posts, just because I've given access to maybe 600 people?
I mean, from a privacy standpoint, yes, because you don't have privacy in that material anymore. I mean, you've disclosed it to the public, and that, say there's like an objectionable picture you may have on there, there's nothing that would stop one of your friends from copying that picture, posting it under their own account that doesn't have privacy settings on it, still, you know, you're still out there. It's just that just because you didn't put it up there doesn't change that. I think that opening anything up to third-party view, like we've learned in Fourth Amendment jurisprudence, defeats a claim of privacy, unfortunately, especially with Facebook. I've gotten in trouble more than once.
What about stuff you do in your Second Life house?
Well, that, I mean, first off, I'm sorry if you have Second Life. But I think actually they've used Second Life in a lot of different programs, economists have, to figure out how people will act in reality, because it's a better way to determine human reaction than a program, because this is real people reacting in real ways. So like say on Second Life you win the lottery, economists can watch how you spend that money in your Second Life, because you'll spend it very similar to how you would have spent it in your real life. So it's a better indicator of your true intentions, I think. So monitoring those things certainly has its dangers, but also its benefits.
I think we'll take all the other questions outside to the atrium for John's reception. Let me offer you, John, a memento from Captain University for an excellent presentation. Thank you very much for joining us today. This is the end of this year's Student Scholar Series. I hope everyone will join us next year to the degree you can. If you're not graduating, faculty friends, thank you very much for participating. And please do join us outside for a reception in John's honor. Thank you very much.
Thank you all for coming very much.